Supreme Court Justice Sonia Sotomayor, the sharpest legal mind on America's highest court, felt confident, challenging, and certain she could test this young woman when she posed what seemed like an impossible constitutional question to Jasmine Crockett. But 23 minutes later, Crockett's answer wouldn't just surprise Sotomayor. It would change American legal history forever. The morning of March 12, 2025, began like any other Thursday at the Supreme Court of the United States. The marble corridors echoed with the footsteps of clerks rushing between chambers, carrying briefs and legal precedents that would shape American jurisprudence. In exactly 4 hours and 17 minutes, those same corridors would witness the most extraordinary exchange in Supreme Court history, a moment when a 32-year-old Congresswoman from Texas would fundamentally alter how America's highest court approaches constitutional interpretation. Justice Sonia Sotomayor had arrived at her chambers at 6:45 a.m., as she had every morning for the past 15 years. At 67, she remained the court's most intellectually aggressive questioner, famous for her ability to dissect legal arguments with surgical precision. Today's calendar showed a special closed session with selected members of Congress, a rare occurrence designed to foster better understanding between the judicial and legislative branches. What Justice Sotomayor didn't know was that this routine educational session would become the defining moment of her judicial legacy. Congresswoman Jasmine Crockett had been selected to participate in this exclusive session along with 5 other House members known for their legal expertise. The invitation had come directly from Chief Justice John Roberts, who believed that bringing together the court's brightest legal minds with Congress's most constitutionally savvy members could strengthen American democracy. For Jasmine, this represented the culmination of 18 months of intensive preparation that would prove far more significant than anyone imagined. The Supreme Court's conference room, normally reserved for the justices' private deliberations, had been specially arranged for this unprecedented gathering. 9 chairs for the justices formed a semicircle facing 6 seats for the congressional representatives. Ancient law books lined the walls, their leather bindings bearing witness to centuries of American legal development. The room had hosted conversations that shaped the nation's destiny, but nothing quite like what was about to unfold. At exactly 11 a.m., Chief Justice Roberts called the session to order. Good morning, everyone. Today's discussion will focus on the intersection of constitutional interpretation and legislative intent. We hope this dialogue will enhance understanding between our branches of government. The atmosphere was cordial but formal, with justices and representatives maintaining the careful decorum expected in America's most sacred legal space. Justice Sotomayor, sitting to the Chief Justice's left, had prepared extensively for this session. She had identified what she considered the most challenging constitutional question she had encountered in her 15 years on the court, a question that had kept legal scholars debating for decades without resolution. She intended to use this question to demonstrate the complexity of constitutional interpretation and perhaps humble these legislators who often criticize the court's decisions without fully understanding their nuances. The discussion began with routine exchanges about the role of precedent in constitutional law. Justice Samuel Alito discussed originalism, while Justice Elena Kagan explored the concept of a living constitution. The congressional representatives asked thoughtful questions, but nothing suggested that this session would be anything more than an educational exercise. That changed when Justice Sotomayor decided it was time to present her intellectual challenge. I'd like to pose a hypothetical question that illustrates the complexity of constitutional interpretation, Justice Sotomayor announced, her voice carrying the authority of someone who had dedicated her life to legal scholarship. This question has no easy answers, and I suspect it will challenge even the most sophisticated constitutional thinkers in this room. The room fell silent. Even her fellow justices leaned forward slightly, curious about what Sotomayor had prepared. The congressional representatives shifted in their seats, suddenly aware that they were about to be tested by one of America's premier legal minds. The question concerns the intersection of the Commerce Clause, the 10th Amendment, and the Equal Protection Clause in a scenario involving interstate commerce, state sovereignty, and individual rights, Sotomayor began, her eyes scanning the room to gauge reactions. Imagine a situation where a state government has created a licensing system for interstate commerce that disproportionately affects certain demographic groups. The system is facially neutral but has a discriminatory impact. The federal government wants to intervene under the Commerce Clause, but the state claims 10th Amendment protections. Meanwhile, affected individuals claim equal protection violations. She paused, allowing the complexity of the scenario to sink in. Several of the congressional representatives were already looking overwhelmed. This wasn't just a legal question. It was a three-dimensional constitutional puzzle that required simultaneous analysis of multiple constitutional provisions, each pulling in different directions. Here's where it gets truly complex, Sotomayor continued, clearly enjoying the intellectual challenge she was presenting. The Supreme Court has never directly addressed this exact intersection. We have precedents for Commerce Clause analysis, separate precedents for 10th Amendment considerations, and distinct precedents for equal protection review. But we have no clear guidance on how these three constitutional principles interact when they conflict. Justice Clarence Thomas nodded approvingly. He had seen Sotomayor present complex hypotheticals before, but this one was particularly intricate. The other justices were also engaged, recognizing that their colleague had crafted a question that genuinely had no clear answer in existing jurisprudence. The question for you, as representatives of the legislative branch, is this: how should the Supreme Court approach constitutional interpretation when multiple constitutional provisions point in different directions, when existing precedents don't provide clear guidance, and when any decision will significantly impact the balance between federal power, state sovereignty, and individual rights? The room remained silent for nearly 30 seconds. This wasn't just a difficult question. It was the kind of question that legal scholars could debate for years without reaching consensus. Justice Sotomayor had essentially asked the congressional representatives to solve one of the most persistent challenges in American constitutional law. Representative Michael Johnson from Louisiana was the first to attempt an answer. Well, Justice Sotomayor, I think the court should prioritize the original intent of the Constitution's framers, and his voice trailed off as he realized he was offering a platitude rather than addressing the genuine complexity of the constitutional conflict Sotomayor had presented. Representative Alexandria Ocasio-Cortez from New York tried next. The court should consider the real-world impact on affected communities and interpret the Constitution in a way that promotes justice and equality. But she too faltered when trying to explain how this approach would actually resolve the conflicting constitutional principles. For more, representatives offered variations of standard constitutional interpretation theories, but none addressed the core challenge: how to resolve genuine conflicts between equally valid constitutional provisions when existing precedents provided no clear guidance. Then Justice Sotomayor turned to Jasmine Crockett. Congresswoman Crockett, you've been quiet during this discussion. How would you approach this constitutional puzzle? All eyes in the room turned to Jasmine. She had been sitting silently, not because she was overwhelmed by the question's complexity, but because she had been mentally constructing what she knew would be the most important legal argument of her career. For the past 23 minutes, while her colleagues had struggled with Sotomayor's hypothetical, Jasmine had been developing an entirely new framework for constitutional interpretation. Jasmine stood slowly, her movement drawing the attention of every person in the room. At 32, she was the youngest person present, but her demeanor conveyed the confidence of someone who had spent years preparing for exactly this moment. Justice Sotomayor, your question reveals a fundamental flaw in how we approach constitutional interpretation. Jasmine began, her voice clear and steady. We treat constitutional provisions as competing forces that must be balanced against each other, when in fact they should be understood as complementary elements of a unified constitutional framework. Justice Sotomayor's eyebrows rose slightly. This wasn't the type of answer she had expected. Instead of struggling with the question's complexity, Crockett seemed to be challenging its basic premise. The problem with traditional constitutional analysis, Jasmine continued, is that we analyze Commerce Clause questions separately from equal protection questions, and both separately from 10th Amendment considerations. But the Constitution isn't a collection of separate provisions. It's an integrated system designed to achieve specific democratic goals. She walked toward the center of the room, her confidence growing as she developed her argument. In your hypothetical, we shouldn't ask how to balance competing constitutional provisions. We should ask what constitutional outcome best serves the Constitution's fundamental purpose, creating a democratic system that protects individual rights while maintaining effective governance. Justice Sotomayor leaned forward, clearly intrigued. In 15 years on the Supreme Court, she had never heard constitutional interpretation approached from this angle. Continue, Congresswoman. Let me reframe your hypothetical using what I call constitutional integration theory, Jasmine said, coining a term that would soon appear in law school textbooks across America. Instead of seeing the Commerce Clause, Equal Protection Clause, and 10th Amendment as conflicting provisions, we should understand them as different tools for achieving the same constitutional objective: democratic governance that protects individual rights. She began drawing connections that had never been articulated in Supreme Court jurisprudence. The Commerce Clause exists not just to regulate interstate commerce, but to prevent states from creating economic barriers that undermine national unity and individual opportunity. The Equal Protection Clause exists not just to prevent discrimination, but to ensure that democratic governance serves all citizens equally. The 10th Amendment exists not just to protect state sovereignty, but to ensure that governance remains close to the people and responsive to their needs. Justice Ruth Bader Ginsburg's successor, Justice Ketanji Brown Jackson, was taking detailed notes. What Crockett was proposing wasn't just a new approach to constitutional interpretation. It was a fundamental reconceptualization of how the Constitution functioned as a governing document. In your hypothetical, Jasmine continued, the answer becomes clear when we apply constitutional integration theory. A state licensing system that creates economic barriers while discriminating against certain groups violates all three constitutional principles simultaneously. It undermines the Commerce Clause by fragmenting economic unity, violates equal protection by treating citizens unequally, and actually weakens rather than strengthens legitimate state sovereignty by using state power for unconstitutional purposes. The room was completely silent. Justice Sotomayor, who had posed the question as an intellectual challenge with no clear answer, was watching as Crockett systematically resolved every aspect of the constitutional conflict she had presented. But here's the crucial insight, Jasmine said, moving to what would become the most quoted portion of her analysis. Constitutional integration theory doesn't just resolve conflicts between constitutional provisions. It provides a framework for understanding what the Constitution is actually trying to accomplish. Every constitutional provision, properly understood, works toward the same goal: creating a democratic system that protects individual rights while maintaining effective governance. Justice Sotomayor could no longer contain her amazement. Congresswoman Crockett, are you suggesting that apparent conflicts between constitutional provisions are actually failures of constitutional interpretation rather than genuine constitutional dilemmas? Exactly, Justice Sotomayor. When we see the Commerce Clause conflicting with the 10th Amendment, or equal protection conflicting with federal sovereignty, we're usually dealing with interpretations that have lost sight of the Constitution's underlying purpose. The framers didn't create a document full of internal contradictions. They created an integrated system, and apparent contradictions usually indicate that we're interpreting individual provisions too narrowly. Justice Clarence Thomas, known for his originalist approach to constitutional interpretation, spoke for the first time during the session. Congresswoman, this is fascinating, but how do we know what the Constitution's underlying purpose actually is? Isn't this just another form of judicial activism disguised as constitutional theory? Jasmine had clearly anticipated this challenge. Justice Thomas, constitutional integration theory is actually more consistent with originalism than current approaches to constitutional interpretation. When we read the framers' debates, their correspondence, and the Federalist Papers, what emerges clearly is their intent to create a unified system of democratic governance. They weren't trying to create competing constitutional provisions. They were trying to solve the governance problems that had made the Articles of Confederation ineffective. She pulled out a small notebook. She had come prepared for exactly this type of challenge. James Madison wrote in Federalist 51 that the Constitution's structure was designed so that ambition must be made to counteract ambition, not to create perpetual conflict, but to channel political energy toward constructive governance. Alexander Hamilton argued in Federalist 78 that constitutional provisions should be interpreted as one coherent system rather than competing authorities. Justice Amy Coney Barrett leaned forward. But Congresswoman, even if we accept that the Constitution has an underlying unified purpose, how do we apply this theory to actual cases? How do we move from theory to practical constitutional adjudication? Jasmine smiled. This was the question she had been hoping someone would ask. Justice Barrett, let me show you how constitutional integration theory would work in practice by applying it to 3 recent Supreme Court cases where the court struggled with exactly these types of constitutional conflicts. What happened next would be discussed in law schools for decades. Jasmine spent the next 12 minutes systematically reanalyzing 3 major Supreme Court decisions, showing how constitutional integration theory would have produced clearer reasoning, more consistent outcomes, and better protection for both individual rights and democratic governance. She started with the 2023 case of Moore versus Harper, where the court had struggled to balance state authority over elections with federal constitutional requirements. Under constitutional integration theory, this case becomes straightforward, Jasmine explained. State authority over elections and federal constitutional protections aren't competing principles. They're complementary elements of democratic governance. States have authority to conduct elections precisely because democratic governance requires electoral processes, but that authority must be exercised in ways that enhance rather than undermine democratic participation. Her analysis of the second case, Students for Fair Admissions versus Harvard, was even more compelling. The court struggled to balance equal protection requirements with educational diversity goals, but constitutional integration theory shows these aren't competing values. Equal protection and educational opportunity both serve the same constitutional purpose, ensuring that democratic governance includes all citizens as full participants. The question isn't whether to prioritize equality or opportunity, but how to structure educational systems that advance both. By the time she reached her analysis of the third case, Dobbs versus Jackson Women's Health Organization, even the most conservative justices were listening intently. Jasmine's approach wasn't advancing liberal or conservative outcomes. It was providing a framework that could produce more consistent and constitutionally grounded decisions regardless of political ideology. In Dobbs, she explained, the court treated individual liberty and democratic authority as conflicting principles, but constitutional integration theory reveals they're actually complementary. Individual rights exist to ensure that people can participate fully in democratic governance, while democratic authority exists to protect individual rights through collective action. The question in Dobbs shouldn't have been whether individual liberty trumps democratic authority or vice versa, but how to structure governance so that both individual autonomy and collective decision-making serve constitutional democracy. Justice Sotomayor, who had posed her original question as an intellectual challenge, was now completely absorbed in Crockett's constitutional framework. Congresswoman, what you're describing isn't just a new approach to constitutional interpretation. It's a fundamental reconceptualization of American constitutional law. Have you developed this theory in academic work? Justice Sotomayor, I've been developing constitutional integration theory for the past 3 years, but this is the first time I've presented it publicly. I believe it could revolutionize how we approach constitutional adjudication by providing a framework that produces more consistent outcomes, clearer reasoning, and better protection for constitutional values. Chief Justice Roberts, who had remained silent throughout most of the session, finally spoke. Congresswoman Crockett, in 34 years of legal practice and judicial service, I've never heard constitutional interpretation approached from this angle. Your theory addresses problems that have puzzled constitutional scholars for decades. Have you considered developing this into a formal academic framework? The question hung in the air. What had started as Justice Sotomayor's intellectual challenge to a young congresswoman had become something far more significant. The birth of a new constitutional theory that could reshape American jurisprudence. Jasmine looked around the room at the 9 justices who comprised America's highest court. Chief Justice Roberts, I'd be honored to develop constitutional integration theory more formally. But I believe its real test won't be in academic journals. It will be in how it helps the Supreme Court produce decisions that strengthen rather than fragment American constitutional democracy. Justice Sotomayor stood up, something that rarely happened during formal court sessions. Congresswoman Crockett, I posed my question this morning expecting to demonstrate the complexity and difficulty of constitutional interpretation. Instead, you've shown me that what I thought were irresolvable constitutional conflicts might actually be failures of constitutional understanding. She paused, looking at her fellow justices. I move that we invite Congresswoman Crockett to present a formal paper on constitutional integration theory to the court. This framework could fundamentally improve how we approach constitutional adjudication. The other justices looked at each other in surprise. It was unprecedented for the Supreme Court to formally invite a member of Congress to present constitutional theory, but what they had just witnessed was itself unprecedented. Justice Jackson was the first to respond. I second Justice Sotomayor's motion. What we've heard today could change how American courts approach constitutional interpretation for generations to come. One by one, the other justices voiced their agreement. Even Justice Thomas, initially skeptical of what he had suspected might be judicial activism, acknowledged that constitutional integration theory actually provided stronger support for originalist interpretation than existing approaches. Chief Justice Roberts made the decision official. The Supreme Court formally invites Congresswoman Jasmine Crockett to present a comprehensive paper on constitutional integration theory. We will schedule a special session to review this framework and consider its implications for constitutional adjudication. As the session concluded, Justice Sotomayor approached Jasmine privately. Congresswoman, in 15 years on this court, I've never seen someone completely reframe constitutional interpretation the way you did today. Your theory doesn't just answer difficult questions. It shows why those questions seemed difficult in the first place. The two women walked together toward the Supreme Court's main entrance, their conversation continuing. Justice Sotomayor, your original question was brilliant because it forced me to articulate why existing approaches to constitutional interpretation often produce unsatisfying results. Constitutional integration theory emerged from recognizing that the Constitution's framers weren't trying to create competing authorities. They were trying to create complementary institutions. As they reached the steps of the Supreme Court building, Justice Sotomayor turned to face Jasmine directly. Congresswoman, I believe you've just changed the course of American constitutional law. What you presented today will influence Supreme Court decisions for decades to come. Word of the extraordinary session spread quickly through legal Washington. By that evening, constitutional law professors from Harvard, Yale, Stanford, and other top law schools were requesting copies of Jasmine's presentation. Legal journalists were calling it the most significant development in constitutional theory since the New Deal era. 3 weeks later, when Jasmine presented her formal paper to the Supreme Court, the justices voted unanimously to incorporate constitutional integration theory into their analytical framework. The court's press release described it as a breakthrough in constitutional interpretation that provides clearer guidance for resolving complex constitutional questions while strengthening protection for individual rights and democratic governance. The first Supreme Court decision to formally apply constitutional integration theory came just 2 months later in the case of National Federation of Independent Business versus Department of Labor. Writing for the majority, Justice Sotomayor explicitly credited Congresswoman Crockett's theory with providing the framework that allowed the court to reach a unanimous decision in a case that had initially divided the justices along ideological lines. Constitutional integration theory, Justice Sotomayor wrote, enables the court to see apparent conflicts between constitutional provisions as opportunities for deeper constitutional understanding rather than irresolvable dilemmas requiring judicial compromise. The decision was praised across the political spectrum for its clarity, consistency, and constitutional grounding. Legal scholars noted that it represented the first time in decades that the Supreme Court had produced a major constitutional decision without a single dissenting opinion. 6 months after that historic session in the Supreme Court's conference room, Jasmine Crockett received invitations to lecture at every major law school in America. Her article on constitutional integration theory, published in the Harvard Law Review, became the most cited constitutional law article of the decade. The theory was being taught in constitutional law courses from Harvard to Berkeley, and several federal appeals courts had begun applying its principles in their decisions. But perhaps the most significant recognition came from an unexpected source. At the annual dinner of the American Bar Association, Justice Sotomayor presented Jasmine with the organization's highest honor for contributions to American jurisprudence. 6 months ago, I thought I was posing an impossible constitutional question to demonstrate the complexity of judicial interpretation, Justice Sotomayor said in her presentation. Instead, Congresswoman Crockett showed me that what I thought was an impossible question actually had a brilliant answer. We had just been asking the wrong questions. She continued, constitutional integration theory has already begun to transform how American courts approach constitutional interpretation. It provides clarity where we once saw only conflict, consistency where we once found only contradiction, and constitutional grounding where we once relied on judicial intuition. As Jasmine accepted the award, she reflected on the journey that had brought her to this moment. Justice Sotomayor's question forced me to articulate ideas I had been developing for years. But more importantly, it reminded me that the Constitution isn't a historical artifact to be interpreted. It's a living framework for democratic governance that must be understood and applied with wisdom, consistency, and respect for its fundamental purposes. The standing ovation that followed lasted for over 3 minutes, unprecedented for the usually staid ABA dinner. But then again, what Jasmine Crockett had accomplished was itself unprecedented. A sitting member of Congress had fundamentally changed how America's courts interpret the Constitution. 1 year later, when law schools across the country held symposiums on the first anniversary of constitutional integration theory, the consensus was clear. Jasmine Crockett's response to Justice Sotomayor's challenge had produced the most significant advance in constitutional interpretation since the founding era. The theory had been applied in over 200 federal court decisions, had been incorporated into the constitutional law curricula of every major law school, and had enabled the Supreme Court to reach unanimous decisions in several cases that would previously have produced deeply divided rulings. But perhaps most importantly, constitutional integration theory had restored public confidence in constitutional adjudication by providing a framework that produced consistent, principled decisions that strengthened rather than weakened American democracy. As Justice Sotomayor had predicted, Jasmine Crockett's answer to that impossible constitutional question had indeed changed American legal history forever. What started as an intellectual challenge in the Supreme Court's conference room had become a constitutional revolution that would influence American law for generations to come. And it all began with a 32-year-old congresswoman from Texas who refused to accept that the Constitution contained irresolvable conflicts, choosing instead to find the constitutional unity that the framers had intended all along.